Good morning and welcome to today's webinar on keeping up with Oregon's changing workplace laws, pay equity, and more. I am your moderator for today, Suzi Weir, and I am the VP of People Development and Culture at Xenium. HR is in a constant state of flux. Between new laws, cultural shifts, and changing markets, the best practices that govern our day-to-day professional lives need to be fluid and changing. So our plan today is to give you some practical skills to deal with those laws that are in a current state of unknown, using Oregon pay equity as our primary example. Luke Reese is our key presenter today. He's going to start by introducing everyone to the legal process that ultimately guides how we come to apply these laws. And I'm going to add hopefully some practical advice on how to best deal with employee concerns that arise, while the lawyers like Luke are fighting the fights that will eventually lead to more defined best practices. So our goal is that you will leave this discussion with some tools to avoid your organizations from being part of those test cases that are going to cost less prepared companies significantly. First, quick housekeeping items. This is a 30-minute presentation, and we will leave about 10 to 15 minutes at least for Q&A. If you have questions, we will take those at the end of the presentation. So please make notes of those questions or feel free to go ahead and type them in the chat window. At the end of this session, and certainly by tomorrow, we will be sending out a recording of this webinar and any complimentary materials to all folks that registered. And if you'd like to get alerts about new events, webinars, or content, feel free to subscribe to xeniumhr.com. And if you're not sure how to subscribe, you can just go on our website at xeniumhr.com, and there's a live chat window. You can type the word subscribe and enter your email address, and you will be on the list. So it's a real treat to have Luke Reese with us today. Luke is a shareholder and attorney at Garrett Heeman Robertson in Salem, Oregon. His areas of practice include civil litigation, employment, and labor law. We can't recommend Luke enough. He has been a great partner, super valuable resource to Xenium as we serve our clients. And as I stated, I'm Suzi Weir, and I will be serving as the moderator and facilitator wearing the HR hat. So I'm now going to turn it over to Luke, and he will talk about what we are covering today.
Thanks, Suzi. I sure appreciate the opportunity to give an overview of how laws are made. And the reason that I think that'll be helpful to all of us is one of the challenges that I face when I'm advising companies on how to deal with new laws like the pay equity law that Oregon's just adopted. I find myself getting asked questions a lot of, Luke, we read this article in the paper about the new law. We understand generally what it requires, but we don't really have any idea of how to implement it or how we can avoid getting sued by employees who've got concerns. I get asked pretty simple questions like, what should we do? And unfortunately, sometimes my response is, gosh, I just don't know yet. And I get some very quizzical responses when I say I don't know. And the response is, well, why not? And I found that it's helpful for people to understand really how these laws come into play, and then also how we learn how they're going to be enforced and adopted, and how we really generate those best practices that we recommend everybody adopt to avoid getting sideways with their employees, the Bureau of Labor and Industries, or someone else that could cause them big headaches. So to go over this legal process, we start with what's going on down in Salem right now, and that's the legislature meeting to propose new bills. This doesn't necessarily create any obligations to any of us, but it is important that we generally keep a heads up of what the legislature is talking about, because it's going to be reported in the media and our employees are going to start to have questions. For example, right now this week, the legislature is talking about paid family leave for all Oregon workers. That's not something that's in place right now, and we honestly don't know what's going to come of that, but it's likely that your workers are going to start to read about it and have questions about what's going on. I think everybody in the HR field needs to at least generally be up to speed with what's going on there so that you can answer your employee questions. What will happen after the debating process, though, is certain laws are going to be passed. And that is when we start to have rules that actually impact how we have to run our businesses. Using pay equity as the example, 2 years ago, the legislature voted and put in place a bill that really makes it now illegal and have real consequences if you pay people different amounts for the similar work that they're doing. The legislature can put it in place immediately, but most of the time there's a delay and the rule doesn't go into effect until the start of the next year, like we're facing here in January of 2019 with pay equity. A lot of people think that once the statute's written and the legislature passes the bill, that's when we know what the law is. The problem is our legislatures rarely know exactly how the nuts and bolts of these laws that they pass are going to be impact our companies, those of us in the HR world, what we have to do. So when I get questions after the bill is passed, like, for example, how do I protect myself from pay equity claims? The answer at that point is we really have no idea. All we have is this very basic structure of what the new law is, but we don't know any of the specifics. And other than using our best judgment on where we think it's going to go, we remain in the dark. That's where we've been for most of 2018 as everybody's trying to get ready for pay equity. I'm sure most of the people who are listening right now have gone to trainings and probably left a little frustrated because you don't have a lot of specifics that you need to be doing to get ready for this new law. We do start to get some of those specifics in the next step of this legal process, and that's when the state agencies start to fill in some of the gaps that the legislature left with what the actual rules are going to be. For employment issues, the state agency that is almost always involved in this process is the Bureau of Labor and Industries, or BOLI. In addition to investigating employee claims, which I'm sure many people have dealt with BOLI in the past, BOLI also is tasked with writing the administrative rules that really go through the specifics of pay equity and almost every other employment law that we have on the books. Something that we're going to cover in detail later are the BOLI administrative rules for pay equity that really just recently came out. So if you went to trainings last year, it's unlikely that you had the benefit of some of these administrative rules as part of those trainings. And one thing that I want everybody to leave with now is the highlights of those rules, because they do provide some specifics that I'd like you to put in place right now to avoid some of the bigger problems. The next step of the process is when BOLI starts responding to these complaints. Effective January 1st, the law's on the books, so employees can complain that they, for example, feel like they're not being paid equally or that their pay is in violation of the Equal Pay Act. And BOLI has the power to both investigate and issue penalties if they think that there's a violation. We learn a ton on how BOLI goes about these investigations. It helps us understand what they mean when they publish these administrative rules. It also helps to identify what BOLI is finding important when we have these factors that we get to argue when there's a dispute about the rules. At this point, BOLI hasn't had an opportunity to dig into the Pay Equity Act as much as they're going to over the next several months. So although today I don't have a lot of examples that I can give you to say, here's what we know BOLI's looking for and what they find important and what we can do to best position ourselves, you will want to check back in on this topic as we go forward to start to get the benefit of that. There's all kinds of ways to get that information. You can read in the paper what BOLI's doing when they're responding to specific cases that garner some media attention. There will certainly be trainings that I'm sure Xenium will do and others following up once we do have some of these test cases going through the pipeline. And then most of you all have access to your attorneys, and I really encourage you to check in with the attorneys, try to find it at a time when they're not going to bill you for your time, but say, hey, have you had any of these cases? Do you know anybody who's had these cases? What are you learning, and what can I take away from that to implement at my organization? I love to have those conversations with people. One, it's fun to tell war stories, but it also really does impact change. If we can learn something from a case that one of our other clients has gone through or that somebody else has experienced and give you some really finite but simple tips to implement, and that comes in and saves you down the road, it feels wonderful. So I do encourage you to have those conversations with your attorneys, whether they're the or lawyers who work for your organizations or just colleagues that you have. The next step of the legal process is probably the most important for the system that we live in, and that's the lawsuits. Our system, for better or worse, is set up where most of the laws really become well defined once we have cases that are litigated. If anybody has ever seen the letters that lawyers exchange when we're arguing about whether or not someone has a claim, you see those case cites, which don't make a ton of sense when you're seeing them out of context, but all they're saying is somebody has already spent the money and the time to fight this issue, and we know not only what a jury has done, but what judges and the Court of Appeals have said is really meant by these statutes that the legislature wrote and these administrative rules that BOLI and other organizations are reading. The lawsuits are great because they are specific examples. Some way that I look at this is the Americans with Disability Act and that interactive process that a lot of us have to go through when we have an employee with a disability come ask us for an accommodation. 20 years ago, that was a really scary process because the rules were new and we didn't have a whole lot of examples to draw upon. Today, though, we have the benefit of 20 years of litigation, and there's a lot of real-world examples that I can give to address just about every interactive process scenario. So instead of me saying, hey, I understand your problem, this is what my gut says, but no guarantees if I'm right or wrong, I can now say, this is how I recommend that we go about resolving this issue, and I'm almost 100% confident it's going to work because this other company has gone through the process and proven it to be right. The downside of this process is, first, it takes a long time to build that history of case law. It's decades, not years, before we really have enough of those cases out there to be able to address most of the situations that arise on a day-to-day basis. The even bigger concern is it is extremely expensive to fight these fights, and somebody has to do it. So I have made it my mission that none of my clients end up being those test cases. When you are litigating an issue that hasn't been litigated in the past, it's great for the lawyers. We get to make all kinds of fun arguments. We find ourselves in court more often and we get paid a bunch of money. But it is not a fun process if you're the poor company or organization that has to go through that. Not only is there the expense, but there's the very real impact that lawsuits have on an organization's culture. Even if it's somebody who no longer works with you who's filing the suit, I've never seen a company be better off because they have defended an employment claim. It inherently is something that you want to avoid. So what I'd like to do now is use pay equity to go through and confirm the information that we have, both what we got from the legislature and now we have from the BOLI rules, and then talk about some practical tips about how to use those to best position you to deal with these laws so that you don't become the test case and have to litigate as we build those case law and how this is actually going to play out over the next several years. So pay equity was passed by the legislature several years ago, but that didn't go into effect until January 1st. What we knew as soon as the legislature voted to make this into a law is that effective January 2019, it's illegal to discriminate against an employee in total compensation because of the employee's race, color, religion, sex, sexual orientation, marital status, veteran status, disability, or age. This makes sense, and it's pretty easy to comprehend. It basically means that we need to pay people similar for similar work done. The way that I've been describing this and the way that I've heard it described by some bully investigators is the days of taking advantage of employees who don't negotiate well are done. And that's a big paradigm shift. I know at the firm that I work at, we have a fine history of new employees being able to negotiate their rate up. That just is now not going to fly. You cannot say, I am paying this person more because they asked for it and this person less because they didn't. It is illegal, and it's something that we need to be mindful of as we start setting pay going forward. The other thing that the legislature did that we've known about since the law was passed is employers are going to need to take immediate steps to correct discrepancies without reducing pay. What this basically means is you can't wait for somebody to make a complaint before you start to make corrections. We'll talk in a little bit about ways that we can go about doing this, but it really does mean that starting right now, we need to make sure not only that we don't have discrepancies, but that when we identify them, we're doing something about it. What that something is, it can change depending on the circumstances, but trying to ignore the issue and then plead ignorance as bliss later on is going to create a lot of risk and some potential problems. The other issue that the legislature threw upon us is if you identify problems, you can't reduce people's pay to correct them. What the legislature has said is if there are pay discrepancies, you need to bring people up to those employees who are paid the most. That could create problems when you have outliers of people who are paid well above market. And we can talk about some tools of how to deal with that. But the legislature was clear, and it's right there in the statute, that corrections need to be made up, not down. The other thing that the legislature threw out is something that is meant to help out organizations. And that's this idea that if you do a full-blown pay equity analysis and identify issues and are taking steps to correct those, if you find yourself in litigation down the road, you've got some safe harbor protections. You're not immune. It doesn't mean that you can't get sued, and if you do, the case is just going to get dismissed, but it really limits your exposure on what an employee could get if they're able to successfully show that there was some discrepancies that violated the law.
Is that, Luke, is that kind of like the affirmative defense that we talk about sometimes with offering harassment prevention training?
You know, I think some people are interpreting as that, and that would be a bit of a mistake. So in the harassment world, we have this defense that's really important and really effective, that if you take immediate action upon learning of a harassment complaint, you investigate it and you take appropriate action, you can't be held liable for the underlying misconduct. Really powerful. The pay equity analysis is a little different. It says that if you're taking proactive steps, the people who sue you can't recover as much as if you didn't have it. So you can still be liable. You can still have to pay the employee and their attorney some money. But instead of what they're cutting off is punitive damages and back pay. So it really limits it. What I will tell you, the bigger benefit of the pay analysis is being able to show, especially bully, but others, that you're being proactive. So it has some statutory benefit, but for the most part, it's that great evidence to say, hey, we weren't trying to be ignorant on all this.
Good faith.
Yeah.
Effort, yeah.
So that's what we have known since this law was passed. But again, just recently, BOLI issued these new administrative laws that provide some real insight into the nuts and bolts of how we're going to implement this. This next slide that we've created is filled with a ton of information, and it's not meant to be overwhelming, but my hope is you can print this off and use it as a DEX reference, because this is information that I expect most people won't have yet. The first one is that BOLI has confirmed that employee just means Oregon-based employees. So if you're an Oregon company and you have employees who work exclusively out of state, they're not covered in this law. Doesn't mean it's a good idea to have huge pay discrepancies between your Oregon and non-Oregon employees, but it does mean we don't have to be worried about being sued if the reason for the discrepancy is somebody's out of state. It also means that if we're going to do the analysis, we probably want to have it focused just on Oregon, or at least consider just focusing on Oregon to avoid creating problems that we wouldn't actually have if we didn't voluntarily do it. The next thing that BOLI confirmed through these administrative rules is that compensation means everything. They wrote down that it includes wages, base salary, bonuses, fringe benefits, equity grants, hiring bonuses, and it's very clear that their intention is any perk that you give to one employee, you need to give to others or risk being in violation of this new law. One thing that has come up a ton that they also were kind enough to clarify is what happens with the benefits that employees turn down for whatever reason. So the big one would be health benefits. When you have an employee who chooses to be on their spouse's benefit plan, BOLI made clear it's the benefits that are offered, not the benefits that are received. So if you've got somebody who turns it down, you're not obligated to somehow even out the scale by giving them more money. In fact, although you can do that, you've got to make sure that you're making that offer available to everyone or risk running afoul of this rule in a whole different way. This next one is incredibly important, and I want to make sure that everybody is aware of this. BOLI made clear that pay disparity can be allowed, but only if it's supported by a list of factors. We've known what these factors are. It's seniority system, merit system, quality or quantity of production, workplace location, travel, education, training, and experience. If you've received any training on this, you've heard those list of factors before. What BOLI did, though, is they have emphasized what they mean by seniority system and merit system. Myself and a lot of people thought when we first read this list, merit and seniority meant that if one of the reasons for discrepancy is someone's been with you longer or someone just does better work, then you should be fine. BOLI has said, really, no. It's not individually saying, hey, this person has more seniority or is better qualified for some reason. They are emphasizing that it has to be pursuant to a system. And what they meant by system is a coherent, consistent, verifiable, and reasonable method for determining merit or seniority. This is really scary to me because I think what BOLI's saying is you have to, separate from any individual worker, implement a formal merit and seniority system to be able to rely on that for pay disparity. We don't know exactly what systems are going to be successful. It's going to take some of those investigations and lawsuits to do it. But we can make sure that if that's the reason that we're going to be paying someone differently, that we do have that formal system that's documented and you can show that you were doing it proactively, not in response to some kind of complaint. You'll see on the slide, BOLI also gave some clarification of what they meant by work of comparable character. They talk about what they mean when they're talking about somebody having a better skill to justify difference in pay. I'll let folks read through those specifically, and really the only reason that I think they're important to see this language that BOLI used is as you start to update your job descriptions and talk about these issues, the more that you can use the specific language that BOLI is using, the better or the easier my job will be if I ever have to defend somebody who BOLI is investigating. We're going to give you a link to the new administrative rules in their entirety, and I do suggest that anybody who's going to be tasked with reviewing job descriptions or is hiring or is talking to employees about this, review those, because again, even if you're just using the same lingo, you're going to be better situated if anybody ever challenges your decisions. Another interesting thing that BOLI clarified in these administrative rules is what happens if an employee voluntarily tells you their former salary information. Part of the rule is now you cannot ask someone for what their previous salary information is, and you can't use that information in setting wages. BOLI was kind enough to say, although you can't ask for it, you're not in trouble if an employee just voluntarily offers it up. Now, the last thing you want to do is try to solicit the information by asking veiled questions, and really the tone that you want your people who are doing interviewers to have is, we don't need that information. but you don't need to do anything drastic. If somebody throws that information at you, you don't have to cover your ears and pretend like you didn't hear it. You are fine if that's something that just comes up naturally. So that's what we know. And if someone's asking me my advice on what to be doing for addressing pay equity, I will say definitively, based on what the rules are and what the statute says, here's what I know we need to do. There's a lot of questions, though, about, well, what do we do, to respond to employee complaints, or what do we do in some of these situations, all those hypotheticals. And I'm happy to give advice on what I think we should do, but it really is just that. It's my thought based on my experience of dealing with some other laws, because again, we don't have those lawsuits. We haven't had people go through the process and have to defend claims. Again, our ultimate goal is to avoid everyone on the call here from having to be in that position. So some tips that I'd like to talk about is kind of what we can do definitively, and then some best practices on how to respond to employee complaints that come up. And this would apply not only to wage equity, but everything. We're always getting new employment laws thrown at us. We always are going to. And having some tools in place so you're confident in how to handle these new laws while we're waiting to get more certainties, something that everybody should have. So looking at pay equity, here are the things that we know we have to do. We know that we have to update our job applications and forms describing what people do. Not only are those helpful just to articulate what somebody's responsibilities are and to hold them accountable if they're not doing it, now with pay equity, that's going to define and really set the tone for where people's jobs are similar so that they need to be paid the same. As you update those jobs, I do think you want to read the administrative rules so that you can use their language. But the key is to have a really good, honest description of what people do and make sure that they line up with what folks are getting paid. Next thing is you need to train the people who are doing interviewers not only on prohibited questions, but how to talk about compensation. The easy thing is no more asking what someone was paid at their previous jobs. Just not a topic we want to talk about. It's at this point akin to asking somebody what their plans are for having kids once they start working, just off limits. But you also want people to be able to talk about compensation. And Suzi, this is one of the questions I would have for you as someone who helps people onboard folks. What is kind of the best practice at this point in kind of our current culture about how you talk to employees about not only what they're going to be paid to start, but what they can expect kind of going forward with the company?
Yeah, well, it's important to have some compensation process, right? So a compensation philosophy about how we're going to compete in the market, right? Whether we want to be below, at market, or above market, that's your business or organizational talent strategy. Mm-hmm. But also, what's your process for determining and making adjustments to compensation? And so creating a pay structure, which we have mentioned at some point in this presentation, is important because if you can articulate, this is how often we review compensation against the market. We evaluate whether we're competitive or we're meeting our philosophy and our strategy. And then here's how often we review mm-hmm. pay and make adjustments. And here's some criteria for how we might make adjustments, so people know what to expect. I find in absence of communication, therein lies opportunities for misconceptions, distrust. So creating an open and safe space for people to ask questions is important. Otherwise, they're going to be talking to other folks or going online and maybe not getting accurate information. So.
Yeah, I mean, we've had kind of a paradigm shift on how we talk about comp. I know when I was coming up through the ranks, the best practice was to say, this is something we don't talk about. We'll pay you what we pay you, and we can talk about adjusting that, but you certainly shouldn't be talking to your coworkers. And there was limited access to what the market was. Mm-hmm. That's just changed. Anybody who's coming into the professional world now not only knows what everybody gets paid just because of the resources that are out there, everyone's free to talk about it. I'm constantly amazed with some of the younger lawyers in our office with not only how freely they talk about it, but how positive they talk about it. So we have kind of a carrot and stick issue going on with how we talk about compensation now. You have the stick, which is the world I live in. If you don't do it correctly, you're bound to get sued under this pay equity, and there's some real teeth to that side of the punishment. But there's also the carrot, where a lot of modern workers want to be able to have this conversation. And if you can train the people who are onboarding folks and doing the interviews to be comfortable talking and to do it in a way that we know BOLI would approve of, I think you're going to not only avoid lawsuits, but find that you're better able to recruit and retain some really high quality talent. The other thing that we know we can do here is to invest in this formal pay equity analysis. Again, it's not the silver bullet that's going to save you from everything, but it is something that you want to take advantage of. We don't know right now what really is meant by pay equity analysis. At this point, that's for everybody to define on their own. The way that I'm looking at this, though, is the more that you can show you were getting outside resources who really know what they're talking about to do a deep dive statistical analysis of how you're paying your folks, the better you're going to be if you do find yourself being investigated by BOLI or getting sued. There's a certain benefit to overwhelming people with the data that you have as we try to figure out what is really meant by the equity analysis, that I suggest if you don't have somebody in-house who can do a true regression analysis and not only identify disparities, but then really dig down to find out why those disparities are there, you'd want a resource that can do that for you. I know Xenium does that. I know there are other folks who do that. And if you're going to do the pay equity analysis, I think my advice is invest in doing it right and get some feedback on what options are available. The last one that I put on here is make sure you have the new poster that's required. I recently got yelled at by one of my clients, not on pay equity, but something else, where they said, hey, I had no idea that BOLI requires you to post a million different things. Why didn't you tell me that? So I've now included this on everything that I talk about pay equity. There's the link. Print it off if you don't have it already, and make sure it's posted with all of your other required postings. So the next thing is how to avoid the suits with the information we have. We can go through this pretty quick. The first is a link to those administrative rules that I talked about. I highlighted the important ones on that previous slide, but anybody who's dealing with this on a frequent basis should read these rules, because as we sit here today, it's the most clear guidance we have on the specifics. Also update those job descriptions and job categories using these rules, and make sure that anybody who's doing your trainings or onboarding is familiar with them as well. Again, with the instructions, really start using this language as much as you can when you're talking about these topics. The last thing is, what do you do when an employee comes to talk to you with concerns? It's a really uncomfortable feeling when you're dealing with pay equity or one of these other new laws of, hey, I've got an employee who has a concern and I don't want to say the wrong thing. My advice is don't worry about that. Of course, you want to be tactful in how you communicate with this, but I have found you run the risk of doing way more harm by being cagey or not having a good, frank conversation than you do by saying, I would happy to talk to you about this. Here's what I know, but acknowledge I don't know everything here. This isn't a law that anyone has memorized, and no one should act like that's a problem. Anecdotally, I defend lawsuits in state and federal court about half the time that I'm working, and almost universally, the people who end up taking issues all the way to court felt that they were left in the dark by their employer at some point. Rarely do I find someone who had a dialogue with a decision maker or a company about their problems that escalates it to that level. So I know some people, take this approach of the minute that someone starts talking threats or talking lawyers, I don't want to talk to that person anymore. For the HR world, I'd encourage you to have those conversations and establish a dialogue. Now, of course, there are red flags that are going to come up in those conversations that are going to require some follow-up with your attorney or your management team, or however you want to do it. But I do think that, especially when we don't know exactly how we're supposed to handle these situations, keeping the dialogue is a helpful thing. The other thing that we can do is, again, be prepared to have the conversation in a more kind of significant way, not just here's what the law says we can't do, but here's what we're doing to make sure that our employees are paid fairly. When you have employees who come with you with a complaint, it's best that you can move not only from, hey, we're not breaking the law and here's why we're not, but instead of talking about the law, let's talk about all the great things we're doing. So the more that you can do a comprehensive salary analysis and pivot the conversation to that, the better off you'll be. I know I've been rambling quite a bit here, and we've got a few good questions, it looks like. Do you want to take some of those?
Yeah, we can take a couple questions now. So let me go. We have one from Chelsea. Is the pay equity law geared towards all Oregon businesses or just businesses with a certain number of employees?
It's everybody.
Okay, so no size.
Yeah, it's everybody. And what you do in response can change and the potential consequences change the bigger you get. But if you've got employees, you need to be addressing this. It can customize how you do it, though.
Okay. Another question is, you had said, this is from Stephen, you had said you can't pay more to someone who negotiates. Can you confirm that? So the statute says you can't discriminate based on the protected classes. Does that mean you can never pay someone more for negotiating, or only if their negotiation correlates with, it says an impermissible class. So what if a racial minority woman negotiates for a higher starting pay?
It's a great question, and it's the absolute right response when I say you can't negotiate anymore. That's a lawyer response that garners a ton of frustration from people who actually have to hire good talent. It does mean you can't just say the reason that I am paying this person more is because they negotiated. You've got to take that next step and say the way they negotiated justifies pay in a way that the statute contemplates. And what I really mean by that is you have to say they negotiated well by pointing out that their expertise or their skill or another thing that falls onto that bona fide list of factors that we talked about earlier is the reason that they're getting paid more. So when you're going through negotiations, especially with some of your more highly paid employees, you need to be able to confirm in the hiring process, salary was set after negotiations for the following reasons. And it's the person's skill, their education, their background, something that falls on that list. And again, just to make sure I'm emphasizing probably the most important thing that we know right now, if it's going to be seniority or merit, it needs to be pursuant to that bigger system that applies to everybody, not just a specific employee. So I hope that clarifies that.
And we'll give out contact information at the end of this. So if you have any follow-up questions, you can get those answered. So here's another one. Our application asks not prior salary, but their salary required. Like, so is it okay to ask an applicant what their salary requirements are?
Another great question. It is. The statute doesn't prohibit it, but it kind of goes contrary to the general tone of the statute. And I wouldn't be shocked if, as BOLI starts doing some investigations or lawsuits start being filed, what we find is that becomes evidence of potential discrimination, and we will be advising against it. The tone here is you can't use the employee's desire for what they want to get paid to set the rate. So I would recommend about taking that out of your application unless it truly does help you establish pay, for example, for a new position that you haven't had before.
Okay, we have great questions coming in, so I'd like to continue with those. So here's a good one. If a company has similar jobs, so these are different levels or types, so engineer, senior engineer, principal engineer, for example, can years of experience and some skills be enough for differentiators for pay, even though, right, they're similar type jobs? This this is going to be a challenge for some employers,
Yep.
I think. Yeah.
I think this is a huge challenge for employers, and it's a great example of where the legislature didn't think things through when they issued the rule.
Mm-hmm.
Um, the short answer is yes, as long as you can document using these bona fide factors that it matters. For industry specific, where the legislature wasn't thinking, hey, this is going to be difficult, for example, in the engineering field, what I recommend is having somebody come in and look at it through the industry lens. There are industries where people are paid differently in a way that's not going to make sense to me or a bully investigator on its face. But if it's explained to us by someone who really understands why the positions justify different compensation, then we're going to be okay. I can tell you with my experience with bully, the investigators are open to being educated by people who speak the lingo of the industry. So if you have someone either in-house or a consultant that you can use to say, here's how we set pay, and it's very specific on the type of employees that we're recruiting, their education, where they come from, all that kind of stuff, you should be fine, but you're going to have to be prepared to have somebody who can translate what you understand as kind of common sense to someone who's totally foreign from the industry.
Okay. There are a couple questions about posting pay grades. So, I know there's a lot of question for employers about how transparent do I be, right? How transparent should I be in the recruiting process in terms of posting, what the pay range is, also internal publishing or communication of pay, right? So some folks may do just at the individual basis for your job. Here's the pay range that's been established. I know some employers will actually publish pay grades so all employees can see. What are your thoughts on that?
This is a bit tricky, and my short answer is it really depends on the circumstances. What I'll tell you is what the law encourages is being totally transparent with what people are being paid. That is the absolute tone of what we're being told by our lawmakers and the people who are tasked with enforcing the law. I don't think, though, that the right response is to immediately move from the way people are at right now to this idea where we're being totally 100% transparent with what everybody's being paid. That's too big of a shift, and it's going to have real consequence on your culture and your workforce that I think the benefit of trying to be 100% compliant with the legislature's intention is outweighed. So when you're looking at posting pay ranges, what I would say is look at it from a very big picture. Part of that picture is legal compliance and guys like me telling you that you should be as transparent as possible, but that's a part of the conversation. Another big part is how are our current workers going to respond to that? How are our candidates going to respond to that? How's it going to impact our ability to manage? How's it going to impact the bottom line? At the end of the day, we're all running businesses, and we need to take consideration of all these factors and then make the decision that's best for what we want to accomplish. So again, I apologize that I can't say 100% here's what to do. Maybe after some lawsuits get filed, we'll know what the courts have said we need to do to be compliant, or what is kind of that silver bullet defense if you ever find yourself in that zone. But for now, I would say keep this in mind. Know what Luke would say in the situation, but only have that be part of the bigger discussion.
Yeah, and I would think if you haven't gone to the trouble of really defining and pricing out your jobs and creating a pay structure where there are clear wages for each position, and have done some pay equity analysis to at least have the awareness of what your practices are, then I would be inclined maybe not to post in my job posting the pay range.
Yeah.
People are afraid, right?
Well, and the fear is valid. This really is a big shift. I mean, the legislature threw us a huge curveball here, and you need to be smart on how you respond to it. I'm a big fan of being very honest with my clients that you don't always want to do what I say is the best practice. I try to learn your company. I try to understand it, but you understand it way better than I do. And this is just part of the bigger picture. So
Comp is one of those things you've got to have a plan, and that plan needs to be what works best for you.
Okay, so we have, and there's so many questions, and this is great, and we'd love to answer them. So we'll provide you with an opportunity to ask some questions after this webinar, but we'll take one more for the sake of time. Question is, it's a layered one, but how frequently should a pay analysis be done? This particular person did one 3 years ago and looked at the industry. However, things keep changing, which is a challenge. So to be competitive and compliant.
Yeah, so this one I actually can give the answer every 3 years. The benefit of that safe harbor that we talked about applies with a 3-year look back. So if one of your purposes in doing the analysis is to have that safe harbor, every 3 years is what we should do. I think practically it's a good level of time too. Every year seems like too much unless you've got somebody who can do it in-house and it's really important for recruiting. But from a liability, 3 years is great.
Okay, so we have a lot more information here that's going to be available, and we're sending out the recording as well as the slides and some contact information, so other people will be able to follow up. What we don't have time to dive deep into, and we were really just intending to provide a summary, was there's some legislative activity around paid sick leave. So there's some action items here. Proposed legislation to require paid leave.
Here's what I'll say about paid sick leave. No one understands it 100%. Oregon law is now different than Washington law, is different than federal law, and anybody who says they have an encyclopedic knowledge of it's lying. So be comfortable that no one's going to understand it, and don't be scared to talk to employees about their questions, not having all the answers in one place. That's the people who either act like they know more than they're due or decline to have the conversation are the ones who get themselves in trouble. And the last thing I put on here is recreational marijuana. We don't need to waste a whole lot of time here, but for anybody who's doing business in Oregon, Washington, or California, know what the Farm Act is and what it did with CBD from hemp versus CBD from marijuana. Basically, it's illegal to have hemp-based CBD now, and that is going to be big for employees who think perhaps that all recreational marijuana is valid. This remains one of those ongoing things that right when we think we know how to handle it, it changes a little bit. And again, know what the Farm Act is at this point.
Okay. So if someone, for example, came up positive under your testing process, you might need to dive deeper here.
Correct.
Or I guess if they're under the influence, you could still enforce your policy.
Yeah. Here's my big worry is employees are going to start to realize that CBD from hemp is no longer illegal. They're not going to realize there's a distinction between that and CBD from marijuana. Mm-hmm. They're going to get tested. You're going to test somebody. They're going to test positive for THC. And the employee's going to say, well, wait a minute, it's legal now. And you're going to have to explain, well, no, it's not. This is one of those things where you have to be continuing to not only make sure you understand it, but have a dialogue with your workforce so that you're not dealing with problems that could have been avoided with some bit more information. Farm Act's brand new, and it's just one of those things I don't think was on many people's radar, but seems to be causing a lot of confusion amongst employees who now have a different understanding of what our drug and alcohol policies are.
Okay. So we are at 11:49. So we went a little over, but we were really trying to cover all the content and get everybody's questions answered. Here is some contact information. So Luke Reese is on here. So, you're welcome to reach out to him if you didn't get your questions answered. My information is here too. If you have questions about how Xenia might support you or just general HR inquiries. Also, we have a blog, podcast, webinars available on various topics. So we'd love to continue to serve as a resource for you. So thank you so much for attending today. As previously mentioned, the recording of this webinar will be sent out by tomorrow. Have a great day.
Thanks, everybody.